Good afternoon, my name is William Hughes and I am representing the respondent Jarndyce. One of the fundamental principles of arbitration is for each party to have a hearing by an impartial arbitrator or tribunal. This is a principle upheld by Article 6 of the European Convention of Human Rights. Royal Fund seek to remove one arbitrator from the tribunal of three, Dr. Gagarin. They seek to do this under a challenge to his impartiality or independence. Jarndyce refute this allegation. The Arbitration Scotland Act 2010 are Rules 10 to 16 of the Arbitration Scotland Act. These rules are mandatory. The Act allows for objection of an arbitrator at Rule 10. A party may object to the tribunal about the appointment of an arbitrator that is not impartial and independent. However, before looking at the Act, we must look at the LCIA rules which govern this arbitration, as Rule 14 also states the Outer House of the Scotland Act also states the Outer House may remove an arbitrator or dismiss the tribunal only if that any available recourse to a third party who the parties have agreed is to have the power to remove an arbitrator or dismiss the tribunal has been exhausted. In this case, that is the LCIA. The LCIA Rule 5.3 states that all arbitrators shall be and remain at all times impartial and independent of the parties, and none shall act in arbitration as an advocate or for a representative of any party. No arbitrator shall advise any party on the party's dispute or the outcome of the arbitration. Article 10, Revocation and Challenges of the Rules. 10.1 states the LCIA Court may revoke any arbitrator's appointment upon its own initiative at the written request of all other members of the arbitral tribunal or upon a written challenge by any party if circumstances exist that give rise to justifiable doubts as to the arbitrator's impartiality and independence. Royal Fund have raised a challenge under a single written challenge by any party regarding the justifiable doubts as to the arbitrator's impartiality and independence. The potential areas of this are previous disagreements, physical altercations with directors of a sister company of Royal Fund, Funny Tank Engines, connected through LinkedIn with all counsel for both opposing parties, previous working relationship with and praise from Jarndyce, author of an article advocating a relaxed approach to the performance of contracts in the amusement industry. In response to the allegations by Jarndyce offer the following. In the case of a conflict, we must refer to the IBA Conflicts of Interest in International Arbitration, which act as a guide for arbitrators to decide whether circumstances arise to give rise to any justified doubts as to an arbitrator's impartiality or independence. The IBA guidelines provide specific practical situations which commonly arise in international commercial arbitration, which could, in the eyes of any party, give rise to a conflict of justifiable doubt as to the arbitrator's impartiality. They rank each situation in a series of lists. These lists comprise 4 lists, the first of which is the non-waivable red list. These are items which provide, without doubt, a conflict, and are very often as set out in the case of R versus Bow Street Metropolitan, that no one should be a judge in their own cause or violate the principle of nemo in causa sua. That any disclosure of said conflict cannot rid the parties of the conflict that would be seen as affecting their impartiality or independence. That said, in layman's terms, that if they disclose something that is in those situations that is that serious, they cannot be part of the arbitral tribunal and must refuse the appointment or be removed. None of the accusations made fit in this category. The next category is a waivable red list. This is much the same as the non-waivable red list, but it provides conflicts which require disclosure but are not quite so severe as to warrant the arbitrator to not accept the appointment or be removed. None of the categories that I have heard to date sit in this list. The next list is the orange list. The 3 categories raised sit in this list. These contain situations which may give rise to justifiable doubts as to the arbitrator's impartiality or independence. However, the critical point is that the disclosure of such situations should not automatically result in disqualification of the arbitrator. The list contains a number of situations. Point 3.1.1 refers, the arbitrator has, within the past 3 years, served as a counsel for one of the parties, making the appointment in an unrelated matter, but the arbitrator and the party, or the affiliate of the party, have no ongoing relationship. The fact that Dr. Gagarin has worked in the past with Jarndyce and has received praise from Jarndyce for his work there would fit in this category. However, Dr. Gagarin's previous appointment was 1 year ago. Point 3.5.2 refer to a conflict listed as part of this advice where the arbitrator has publicly advocated a specific position regarding the case that has been arbitrated, whether in a published paper or speech or otherwise. Dr. Gagarin's previous article advocating a relaxed approach to the performance of contracts in the amusement industry would sit under this point. Point 3.4.4 of the Orange List also provides for the following. Enmity exists between an arbitrator and a manager or director or a member of the supervisory board of a party, an enmity that has had a direct economic interest in the award, or any person having a controlling influence on one of these parties or an affiliate of one of the parties or a witness expert. Dr. Gagarin's previous altercation with the director of Funny Tank Engines, sister company to Roller Fun, would again give rise to a challenge under the Orange List of Dr. Gagarin's appointment. In response to these, point 1, as Porter v McGill sets out an English common law position to test the impartiality of an arbitrator, the position it set out was, question is whether a fair-minded and informed observer, having considered the facts, will conclude that there was a real possibility that the tribunal was biased. Jarndyce do not see any reason to doubt that the tribunal is biased. One such case that evidences this is Rustle Trading versus Gill and Doofus, where it is highlighted that where parties have agreed to have their dispute decided by people who are themselves active traders, as is the case in this arbitration, it is very possible that they will have come into contact with the parties in dispute in the past. Dr. Gagarin has come into contact with Jarndyce in the past, but this is more than common for an arbitral tribunal of this nature. It was worthy of note in this case that it was held that the arbitrators were appointed by trade associations and were likely to add commercial dealings with one or both parties in the dispute, but this had never been regarded as sufficient in itself to raise doubt as to his ability to act impartially. In Laker Airways versus FLS Aerospace in 1999, there, following the appointment of an arbitrator who was also a barrister, one of the parties learned that the barrister appointed on behalf of Laker in the dispute had recently taken up a post in the same chambers as the arbitrator. However, the two barristers had never met. The arbitrator was asked by the other party to resign, but refused to do so unless both parties asked him, much is the case here. However, it was found that there was no conflict of interest, that there was no risk of transmission of information between the two barristers, and that there was a risk of familiarity, and that there was no risk of familiarity. In the case we have before us, there is far less substance than in the Laker Airways FLS Aerospace to dismiss to dismiss an arbitrator from the tribunal than there was in that case. To address the second point of Dr. Gagarin's previous iteration of a position in the industry, where an arbitrator stated a view as a witness to the facts in a previous arbitration, which Dr. Gagarin has, his appointment as an arbitrator in a later arbitration, which in the same question is likely to rise, not necessarily liable to a successful challenge. This situation has arisen before in Argonaut Insurance Company versus Republic Insurance, where it was held that almost any underwriter with any experience of underwriting excess of loss of business in London market in the 1970s would have written excess of loss reinsurance of weavers at some time. This is to say, again, that in an industry which is not as large as we have here in the as we have here before us today, that there would not be some crossover of opinions at some time. It should be the case that the tribunal made up of 3 members come to a rational decision based on the facts presented before them in this case. To address the last issue of the previous altercation, we provide no comment on this, and this is for Dr. Gagarin to answer this, whether it is truthful or not. We see no reason to declare this as a conflict, as it sits on an Orange List, which is a choice of conflict to declare, and we have no issue with that conflict. There are many issues which relate to that, whether it is work related, whether it actually happened, whether it was provoked, and we do not see it relevant to the facts presented before us in this case. Dr. Gagarin is a respected individual and appointed to many tribunals, and the fact that there is 2 other members of the tribunal, of which Dr. Gagarin is not the primary member and therefore the casting vote of the tribunal, we see no issue as to let the tribunal remain in place and continue about their work. we feel that the challenge made by Roller Firm at present is a challenge made in order to unsettle the tribunal and done tactically. On that, I close. Thank you very much.